If you carry a firearm, or you live with someone who does, the Supreme Court just changed a rule that affects whether you could be breaking the law the next time you walk into a store, a gas station, or a shopping center. It happened yesterday. The decision came down on June 25th, and most people still have no idea it exists. The headlines mentioned it for a moment and then moved on to the next thing. But the part that actually touches your daily life, the part that decides whether you are carrying legally when you run a simple errand, almost nobody bothered to explain. So that is exactly what I'm going to do right now, in plain English, the way I would explain it to my own family at the kitchen table. And before we go one step further, I want to be honest with you about something, because being straight with you is the whole reason this channel exists. This ruling did change something real, but it did not change everything the loud headlines want you to believe it changed. There is one part of the law that did not move at all, and if you assume that it did, it could land you in very serious trouble. I will get to exactly what that is. Stay with me all the way to the end, because that piece is the one that still trips people up even after this decision. Now, here's the first thing to understand, and it is simpler than the news makes it sound. The case is called Wolford versus Lopez. It started in Hawaii, and the court decided it by a vote of 6-3, with Justice Samuel Alito writing the majority opinion. At the heart of it was a type of law that some people nickname a vampire law. The name comes from the old Dracula story, where the vampire cannot enter a home unless someone inside invites him in first. These gun laws work the same way. They said that before you could carry a firearm onto private property that is open to the public, a store, a restaurant, a parking lot, a shopping center, you first had to have the owner's permission. Not a sign telling you to stay out, actual permission, given in advance, before you ever set foot on the property. Stop and think about what that means in real life. Under a rule like that, you would have to assume you are not allowed to carry into a business unless that business had specifically said yes. And almost no business owner takes the time to put up a sign that says, "Guns are welcome here." So in practice, this kind of law turned nearly every store and every public business into a no-go zone for anyone carrying, whether the owner actually cared or not. That is the rule the Supreme Court just struck down. So what does the law look like now? The court said that requiring permission in advance is an undue burden on the Second Amendment, and it flipped the rule back the other way. In most of the country, the default has always been the opposite of a vampire law. A person carrying a firearm can generally bring it onto private property that is open to the public, unless the owner says otherwise. The owner stays in control, but the burden is on the owner to speak up, not on you to go hunting for permission first. After this decision, that ordinary default is what applies. Permission is assumed unless the property owner tells you no. Now here is one of those questions I promised you, and the answer is probably hanging right in front of you the next time you walk into a business. If you can no longer be required to get permission in advance, then what is the thing that actually decides whether you can carry into a particular store? What do you look for? Hold that question. I am going to answer it in just a minute because it is the single most useful thing in this entire video, and I want you to remember it. First, let me answer the question that is on a lot of people's minds, which is, does this even apply to me? And this is where you need to pay close attention, because the honest answer is that it depends a great deal on where you live. Only 5 states had these advance permission laws on the books. Those 5 states are Hawaii, California, Maryland, New York, and New Jersey. If you live in one of those 5 states, this decision is a direct, immediate change to your daily life, and you should understand it carefully. If you live almost anywhere else, the ordinary default already protected you, so for you this ruling mostly confirms the ground you were already standing on. Either way, it is worth knowing, because these are the rules that govern something you carry every single day. Okay, now to that question I ask you to hold, because here is the payoff. If permission is now assumed, the thing that decides whether you can carry into a business is the owner's own choice, expressed clearly, usually through a posted sign at the entrance. The property owner still has every right to say no firearms allowed. What changed is who carries the burden. Before, in those 5 states, the burden was on you to find a yes. Now, the burden is on the owner to post a no. So the practical lesson, the thing I want you to walk away with, is this. When you walk up to a business, look at the door. If there is a clearly posted notice saying firearms are prohibited, you respect it. Every time, no exceptions. If there is no such notice, the default after this ruling generally falls back in favor of the person who is lawfully carrying. The sign on the door is now the thing that does the talking. Let me explain why the court ruled the way it did, because the reasoning tells you how solid this is. This case is the latest in a line that goes back to a landmark decision the court handed down in 2022, which set a new test for gun laws. Under that test, for a modern gun regulation to stand, the government has to show that there was a relevantly similar regulation back when the country was founded. The supporters of the vampire laws argued that history was on their side, that many early American laws punished people for entering private property without the owner's consent. But the challengers argued, and the majority of the court agreed, that most people in the real world never bother to post signs one way or the other, and so a law like this would quietly turn the vast majority of public spaces into places hostile to anyone carrying. In the words of the majority, that hobbles what the Second Amendment is meant to protect: the ability of ordinary, law-abiding people to carry as they go about their daily lives. Now, in fairness, because you deserve the full picture and not a one-sided story, this was not a unanimous court. It split 6-3, and the more liberal justices dissented. In their view, this decision stripped states of a tool they had deliberately chosen to manage firearms in crowded public spaces, and it shifts the weight onto property owners and the public to sort things out themselves. That disagreement is real, and you should know it exists. But the majority controls the outcome, and the rule I just described is the law of the land as of right now. And here, finally, is the part I told you to wait for. This is the piece that did not change, the one that can get you into serious trouble if you assume otherwise. This decision is about where you may carry a firearm onto private property. It is not, and I want to be very clear about this, it is not a decision about when you are allowed to use a firearm to defend yourself. The rules of self-defense, when you can draw, when you can act, the duty to retreat in some states, the castle doctrine in others, none of that was touched by this case. Not one word of it changed. So if anyone tells you the Supreme Court just rewrote the self-defense rules, they are wrong. And acting on that mistake could be the most expensive error of your life. Where you can carry and when you can use are two completely separate areas of the law. This ruling moved the first one. It left the second one exactly where it was. There are a few more things this decision did not do, and they matter just as much. It did not erase what are called sensitive place restrictions. Government buildings, schools, and other locations that are specially restricted, those remain off limits where the law makes them off limits, and the court did not resolve that part of the dispute at all. It did not eliminate the need for a valid carry permit in the states that require one. If your state requires a permit to carry, you still need it. And it did not strip property owners of their authority. A private owner can still tell you, on their own property, that firearms are not welcome, and you must honor that. So let me bring this home and give you the steps that actually matter. First, know whether you live in one of the 5 affected states: Hawaii, California, Maryland, New York, or New Jersey, because that tells you how big a change this is for you. Second, whatever state you are in, build the habit of reading the entrance. A clearly posted no firearms notice is the owner's lawful choice, and you respect it without argument. It only takes a glance, and that one glance can save you from a charge you never expected. Third, keep your carry permit current and valid, because this ruling did nothing to remove that requirement. Fourth, do not assume you can now carry into sensitive or specially restricted places, because that question was left untouched. And fifth, never confuse where you can carry with when you can use. Those remain two different worlds. Let me recap it all in one breath, because I want this to stick. The Supreme Court struck down laws in 5 states that forced you to get permission before carrying onto private property, and it flipped the default back so that permission is assumed unless the owner posts otherwise. The sign on the door now does the talking. But the court did not change the rules of self-defense, it did not open up sensitive places, and it did not remove the permit you may still be required to carry. Where you may carry moved, when you may act did not. If this made the law clearer for you, do me one simple favor. Send it to someone you know who carries, or who has a firearm in the home, a family member, a neighbor, an old friend. There is a lot of confident, wrong information flying around about this decision right now, and one honest conversation could keep someone you care about out of real trouble. And one last thing, because it matters. Everything I shared here is for education and general understanding only. It is not legal advice, and I am not your attorney. Gun laws differ enormously from one state to the next, and even from one town to the next, and they can change. So before you rely on any of this for your own situation, confirm the current rules with your own state's official resources, or with a qualified attorney where you live. Know the law, respect the door, and stay safe out there.